Hi, I'm attorney Julie Hauf. I wanted to discuss today a recent summary judgment win on a PIP file in Orange County that had 3 issues, all of which were ruled on in our favor. The first is that the plaintiff had failed to file a reply to the original affirmative defenses. The defenses ended up getting amended during the suit after some additional information came to light, and the court order for that, allowing that amendment, required the plaintiff to file a reply within 20 days, which they did not. The plaintiffs' and defendants' motions for summary judgment were heard about a month apart. We had raised the issue of the failure to file a reply at the first summary judgment hearing when the plaintiffs was heard, and the judge reserved ruling until he had heard both. But even though the plaintiff had been made aware at that time that they had failed to file a reply, still didn't file a reply and actually noted to the judge that there was no requirement to file a reply, which, as we know, is not correct. The second issue, this was a case related to a DME invoice that there had been a 6B request about, but also the clinic did not have the DME license at the time. It was I think it was a cervical brace was given, or cervical traction device was given to the patient. So we also raised on summary judgment that they didn't have a license for this. They admitted as much in their deposition. We had the filings from the state as well showing that they did not have that license at the time. So the judge ruled in our favor on that portion as well. Finally, and this one could have been cause for concern based on some other rulings that have come out in this and other jurisdictions, that there had been a 6B request for the invoice in order to determine the proper payment that had been denied from the, or not denied, but couldn't be paid from the beginning because the 6B had never been responded to. And what the court ruled was that asking for an invoice for a device like this is something that's within the purview of the 6B. That was a proper request, even though the adjuster had said in deposition that there was an issue with some other issues of not necessarily knowing what she would have done with the invoice once she had it, as there was a different calculation that would have needed to be done. That didn't matter. So really important summary judgment win. Really happy about this one for our firm. So plaintiff's failure to file a reply, clinic didn't have a DME license at the time something was distributed, and also the 6B request was proper. So happy for this win, and we'll be moving on to our motion for fees and costs in that file based on an expired PFS. If you have any issues like this or are looking to speak about files where similar things might be coming up, you know where to find us. Thanks so much. Have a great day.